Welcome to The Explainer. Today, we're digging into a legal case where one woman's simple request to install solar panels got shot down. And the reason why? Well, it all came down to a single, really powerful legal definition.
You know, it's a question a lot of people are asking these days. But the answer? It's not always so simple. For one resident in Arizona, this exact question spiraled into a full-blown legal battle.
All right, let's get right into it. Meet our petitioner, Elizabeth Flint. All she wanted to do was make a nice, eco-friendly upgrade to her home. Sounds simple enough, right?
But her housing association, the Citation Gardens Cooperative, just said no. Flat out, no explanation. So convinced they were breaking state law, she decided to fight back. She filed an official petition with the Arizona Department of Real Estate.
And just like that, this wasn't just a neighborhood disagreement anymore. It was official. The case was heading to a formal hearing in front of an administrative law judge. Things just got serious.
Now, looking at this from the outside, you'd think Miss Flint's case was a total slam dunk. I mean, it looked open and shut, and that's all because of the very specific laws she pointed to in her petition. Take a look at this. This is the Arizona law. It's designed specifically to stop homeowners associations from blocking solar panels. And that language seems crystal clear, doesn't it? An association shall not prohibit them, period. And here's the magic phrase, notwithstanding any provision. Basically, that means regardless of what your own little rule book says. The state law is supposed to trump any internal HOA rules. So, based on this, how could she possibly lose?
But here's the twist. Citation Gardens didn't even bother arguing about their internal rules. Instead, their defense did a complete pivot. They changed the entire question of the case.
And this, right here, is the absolute heart of the whole legal mystery. This case wasn't really about solar panels. It was about something much more fundamental. Was Citation Gardens even the type of place that had to follow this law in the first place? So let's break down their defense. It came down to 3 core points. 1, the law is for planned communities and we aren't one. 2, Ms. Flint isn't technically a homeowner, she's a member. And 3, tying it all together, we're a nonprofit cooperative, which is a totally different beast. This is where things get really interesting, because the judge immediately picked up on this and zeroed in on the single most important question of the day.
The judge looked at Elizabeth Flint and asked, pretty directly, "So what exactly do you own?" And Flint's answer to that one simple question, well, it revealed everything about the strange, unique structure of a housing cooperative.
So get this, it's this really interesting mix. Flint testified that yeah, she's responsible for her own unit, has to have her own insurance just like a regular homeowner. But she doesn't actually have a deed to the property. What she has is a certificate of membership. She owns a share in the corporation that owns all the land and buildings.
Now this is the legal definition that the whole case hangs on. Flynn's argument was basically, look, the definition includes nonprofits and it doesn't specifically say cooperatives are exempt, so it should apply to me. But this one little phrase became the legal sticking point. The whole ballgame. Does owning a share in a big corporation count as being an owner of a separately owned lot? Everything depended on the answer to that question.
So after hearing all the testimony and going through the law, the judge came back with a decision on April 4th, 2023.
And after all that complex legal argument, all the talk about ownership and membership, the entire case was decided by a single, powerful sentence.
And there it is. The judge ruled that even though they might look alike, a cooperative is fundamentally, legally different from a planned community. The key was that Flint didn't own a separate piece of property. She owned a share of the whole thing.
So because Citation Gardens was not a planned community, that solar panel law, well, it just didn't apply to them. And if the law doesn't apply to you, you can't violate it. Case closed. Petition dismissed.
So, what do we take away from all this? I think it's a huge lesson in how the law actually works. It's not always about what seems right or fair. It's about what the very specific legal definitions actually say.
This whole case really shines a spotlight on the massive differences between these housing models. On the outside, they can look almost identical, a bunch of homes, shared spaces, but underneath, their legal DNA is from 2 completely different worlds.
At the end of the day, Elizabeth Flint's argument, which seemed so perfect on paper, failed because it was aimed at the wrong legal target. The law was a tool designed for planned communities, and she was trying to use it on a cooperative. The specific definition trumped everything else.
And this whole thing leaves us with a bigger, fascinating question about how laws are interpreted. Flint's whole point was, hey, the law doesn't say co-ops are out, so they must be in. But the judge saw it differently, showing that sometimes a legal category is defined by what it is, not just by what it isn't.